Okay, so the book does some interesting stuff with the rest of the chapter. We talk about contract formation, but it sort of repeats itself. So I'm going to try to go through it and try to follow the book so y'all can keep up. But basically, you have 5 elements to a contract: offer, acceptance, consideration, legal purpose, and capacity. An offer, you have to have intent or a real commitment to enter into a contract. An offer can't be done in jest. It has to be definite. It needs to be, termination is what the book talks about, but certainly, if you terminate a contract prior to it being accepted, then there's no offer. So, example, I offer to cut your grass if you promise to pay me $50. That's an offer, okay? You said it's an offer. You're pretty definite. You're going to cut your grass, and there's a purchase price in there for $50. Okay? How about this one? You're on a golf course. You're 10 feet from the hole. You're working a business deal. You say, okay, I sink this putt. You pay me $100,000, and we're done with this deal. Now, I'm not going to sit here and tell you that business deals aren't done that way. However, is that a real offer? I mean, could you go to court and sue over that? I don't think so. And the rationale being is it was done in jest. It was out there, they were making a bet, and obviously that's not a legal purpose. But wasn't an offer? I don't think so. I don't think it's definite enough. I don't think there's enough intent there. And again, you're talking about a $100,000 deal. Okay? Now, I'll bet you $1 I sink this putt from 10 feet out. If you don't pay up that $1, well, then you're just not a gentleman. Okay? And again, there's lots of things we could talk about with that. But let's talk about acceptance. Okay. I remember when I proposed to my wife, I got down on one knee and I opened up the ring and said, baby, will you marry me? And she says, okay. Folks, as far as I'm concerned, that's acceptance. Now, 3 days later, she shoots me a text message and says, that thing we were talking about the other day? Yes. I texted her back. I said, what the heck are you talking about? And she says, oh, I'll marry you. I said, baby, you said okay. That's a contract. All right, very romantic of me, yes, but hopefully you'll find it humorous. Okay. Sure. Yes. These are all acceptance. Now, bilateral is going to be a promise. I promise to do this if you promise to do that. I promise to do that. That's acceptance. Unilateral, you actually have to perform. I'll give you $50 if you cut my grass. The only way to accept that is to cut the grass. Now, keep in mind, once you start performance, they cannot pull back their acceptance or terminate their offer. They can't pull back their offer and terminate it. They have to give you a reasonable opportunity to complete it. But, it is what it is. Now, the mirror image rule is one of those things that says that both sides of the contract have to be the same. If they aren't the same, then the initial offer is terminated and you have created a new counteroffer where the initial offeror now has the power of acceptance. Now, silence, in some cases, is acceptance. It just depends on the surrounding circumstances. My advice to you is always going to be get everything in writing, especially in the business world. Get everything in writing. Get it nailed down, because if you get it nailed down, that will save you the costs and expenses of litigation. And believe me, ladies and gentlemen, I am not cheap. Deposited acceptance, whenever you put the acceptance in the mail, which goes directly with the mailbox rule. You put an offer in the mail. The offer is not received until such time as it is actually read by the other party. However, an acceptance is effective the second you put it in the mail. That's the mailbox rule. Now, there's also consideration. It's a bargain for exchange. Both parties have to give something up. Capacity, one of my favorites. You have to be over the age of 18. You can't be drunk. That sort of thing. Legality, again, another funny one. If you breach your contract to purchase and sell drugs, what's going to happen? We're going to go to court and sue over this, and I'm going to get my drugs. No, you're going to get your face stomped on the side of concrete, or you're going to die. Okay? These contracts are not enforceable. Now, what about terminating a contract? It can be within the contract itself. The offer can say, I'll leave this offer open for 3 days. But once that 3 days lapses, guess what? There's no longer an offer. A certain lapse of time, and this is a reasonable standard. How long is an offer to buy bananas in August on the docks in Savannah, Georgia, when it's 100 degrees outside and 100% humidity? It's about 2 seconds. Why? Because after that 2 seconds, those bananas have spoiled. Okay? And then obviously, I talked about marrying my wife, and will you marry me? Ladies, all I have to ask is, how long is a diamond good for? Forever, right? Okay. Now, is an offer to marry really good for forever? Probably not. It will be a reasonable amount of time for the young lady to say yes or no. Rejection, no. No. Okay. Revocation. Can both parties agree to revoke the offer? Sure. Destruction of the subject matter. I offer to sell you those bananas. Well, the bananas get stolen by pirates. You can't accept something if it's not there. Offers death or insanity. I offer to sell you these bananas, and I die. Can you accept it? No. Performance becomes illegal. All of a sudden, it becomes illegal to purchase and sell bananas. Okay? Consideration. Consideration is probably the hardest part of contract formation. But the thing you have to understand is that both sides have to give something up. Something of legal value. Something bargained for. Right? Past consideration. That's not going to work. It has to be something now. I agree to do this thing, cut your grass, and you agree to give me $50. What are we both giving up? Well, I'm giving up time and talent to cut your grass. You're giving up $50. Both parties are giving something up. Promissory estoppel. This is instead of consideration, you have promissory estoppel. There's no consideration, but you have detrimental reliance, and there's some injury. The one I like to use with this one is Gulfstream. Gulfstream is a plane manufacturer in Savannah, Georgia, and they hire lots of engineers. So they call up Georgia Tech and say, hey, Georgia Tech, if you will give us 5 of your graduates each year and have them come work for us, we'll give you this wonderful piece of equipment that costs $10 million. Okay? Well, what does the dean of the college do? He gets on his horn. He starts recruiting. He gets more engineers to come to Georgia Tech as opposed to MIT. And says, heck yeah, we're going to do it. And then Gulfstream calls up a few weeks later and says, oh, I was just kidding. Where's the consideration? There is no consideration here. However, that dean at Georgia Tech relied to his detriment on the offer that was given by Gulfstream. As such, he has economic injury. He's tried to recruit. He's gotten more people out there. He's sent people on vacation trips not vacation trips, but recruiting trips. He's gotten facilities ready for this new piece of equipment. All of these things he has done in anticipation of getting this wonderful deal from Gulfstream. And so he's entitled to be compensated. That's promissory estoppel. Capacity. Minors. Certainly, minors can't enter into contracts because they're minors. But there are exceptions to this. Certainly, if the child needs necessities, he can enter into contracts for those necessities. But keep in mind that he can also void those contracts. And that's the example I was talking about earlier in the chapter, where a kid goes and buys a Porsche. That purchase is voidable at the discretion of the child. Now keep in mind, don't anyone here who's under the age of 18 go start buying Porsches. There are certainly remedies for the Porsche dealership, and keep in mind the Porsche dealer is probably not going to sell to you anyway unless you have a co-signer. Why? Because they know the law too. Intoxicated persons. Yeah, I'm sure none of you have ever had a sip of alcohol, and certainly have never been in a state where you couldn't think for yourself. However, there are people out there that get drunk and make deals in bars. Now, are these truly contracts? Well, probably not. They didn't have capacity to enter into the contract. And same thing with mentally incompetent or mentally impaired. Keep in mind that when you are mentally unable to enter into a contract, you can't enter a contract. But you could have what we call a lucid moment, meaning that in that moment in time, you were lucid, you did understand what was going on, so you could enter into the contract. However, if you have been adjudicated incompetent, you can't enter a contract at all. You'll have a representative or a guardian representing your interests who would enter the contracts for you. And then we have lawful purpose. And again, I see lawful purpose, and all I can think about is Tony Soprano. Okay. Yet the contract has to be legal. All right. Restraint of trade. Those are going to be illegal contracts or void. Gambling, usurious, unlicensed, exculpatory, unconscionable, prohibited, covenants not to compete. Again, all these are for unlawful purposes. And again, purchase and sale of drugs. And just think about it. Could you imagine going to court as a drug dealer saying, hey, my supplier didn't do this, they're in breach of contract, I want my profits? It just makes me laugh.